and people have been admitted, and they do a mock class, not the orientation like 3 days before class starts. This is like months before. You didn't do that. Did you find it useful? So the mock class, I'm asking because I have to teach this for the first time. And there's actually teach a class where no one's done the reading yet, right? I'm going to do the Fox case, Pearson. How should I do it? Because I don't want to scare them away because I want them to come here. But like, what would actually be useful? No. I cold called during the orientation. No, were you in the orientation for any of you? I cold called, right? Whatever. Okay, you guys. When I do the orientation for the incoming 1Ls, I cold call. I make it very realistic, just how I do it here. So, okay. So none of you have any advice for me? No, okay. Well, yes.
Did it really well. She just gave us a hard copy of the case and kind of walked us through Iraq.
Okay, so you didn't read in advance.
No.
Okay, guys, one at a time. Guys, yeah, right, Anna. Right. Right. So I was told that my students will not have read the case in advance. They'll get in the case 15 minutes beforehand. All right. Well, but pity those souls. Yeah, no, I'll make it fun. All right, anyway, not important. I want to spend more time. Okay, let's move on. We're moving forward. So last class we discussed recording systems. The important things for you to take away, and I read all of your minute polls, is how to use the grantor grantee index. Yes, Alexis. I'm sorry. You know what? You're right. I gotta just give me 1 second. Thank you for reminding me. Sometimes it logs me out and it doesn't let me start the thing. All right. So what we talked about in class last class was the grantor grantee index. And I think it's very important that you learn how to use those effectively. If you're not sure, you can come talk to me. But I ask those sorts of questions on the exam almost every year. So just be ready for that. We also talked about ORV buyers, right? With what are the duties imposed upon a prospective buyer? And the court says, no, you don't need to check alternate spellings. But as a realistic matter, if you are a competent title search company, you're going to check all the variable spellings, right? You're going to check the different maiden names, the married names, and different things of that nature. Okay? Okay, Alexis, working now for attendance? Okay, very good. Thank you. Yeah, just always remind me if it doesn't work. That clicker is pretty good, but it isn't. Sometimes doesn't always work as I want to. Okay. Today's topic gets a little more tricky. We're talking about chain of title. Chain of title. And the reason why this topic is sort of tricky is it involves somewhat complex fact patterns where different people are buying the same property from the same seller. So you have one seller and multiple buyers. And maybe they have notice of the prior purchase, maybe they don't. Maybe they record, maybe they don't. And the facts are very specific. To make the topic a little bit even more complex, there are different types of recording statutes. We have the race statute, RACE. We have the notice statute. And then the most complicated of them all, the race notice, which is sort of a hybrid of the three. Okay? With me so far? Let's start off with a very simple question. I actually added at the end. I called it question 0 because I already numbered them. I didn't feel like renumbering them all. But question 0 for you all, short answer. What is constructive notice? What is constructive notice? Take about 45 seconds. And who's my next friend? Okay, that'll be for you. Funny, in court, you call your opposing counsel friend, right? It sounds much friendlier. So I call my students friend, but you don't think I'm your friend. Poor mentor, maybe. Okay, another 10 seconds and I'll stop it. Okay, I'll stop it here. Kayla, so first off, let me ask you a follow-up question, an easier question. What is actual notice? I'll get to your question in a minute. What's actual notice?
When you're receiving knowledge,
More precise, you're exactly correct. You're receiving knowledge, but what exactly does it mean to have actual notice?
like an example,
I can maybe start that way.
like handing someone an actual piece of paper that
Right. What does handing them the paper prove? I mean, if you're in court, what are you actually trying to prove by handing them a piece of paper? That they are.
the paper, for example, is used.
If someone saw a piece of paper saying that you had purchased Blackacre, what knowledge can we impute to them? What can we assume they know? Yeah, actual knowledge that they actually know what happened, or we might want to say personal knowledge, right? So if I go tell my neighbor, hey, um, you know, Bill sold Blackacre to Johnny last year. You shouldn't have bought that from him. That's an example of actual knowledge. Or to use Kayla's example, which I like, I hand someone a deed saying, "Look, you idiot, I bought Blackacre last year. This is mine." Right? That's actual knowledge. When there's actual knowledge, these cases are actually very easy. The more difficult ones involve the term I asked you to do up here for Grayson. Grayson, what is constructive notice? What it's a bit harder to define. What's constructive notice?
Notice the law deems someone to have regardless of their knowledge.
So it's not actual notice, something less than actual notice, right? Okay, good. If you have actual notice, you're good, right? You're on notice. But if you have something less than that, the parties will litigate if there's something called constructive notice, right? Something less than actual. Elise, let me ask you a follow-up. Give me an example of what constructive notice might include. Okay.
Was unaware, but like that person built a house on it.
Oh, that's good. Let me make my question more precise. Give me an example in the context of chain of title of constructive notice. That's more relevant for us today. You're exactly right what you said. It's absolutely constructive notice, but in the context of today's class. What might example be of constructive notice that something's up? Oh, that's good. Yeah. So an example of constructive notice might be what's called record notice, RECORD, record notice. So let's say at some point in the past, O sold Blackacre to somebody else, and that deed was recorded. But you, the new buyer, didn't do your homework. You did not perform your due diligence. You didn't check the chain of title. So as a result, there's a record in the county courthouse, which you didn't find. And to go back to Grayson's definition, the court presumes that you should have been on notice to locate this deed. It was taking you a simple search. You search, okay, when did O sell Blackacre? Okay, it might take you a couple hours, whatever it is, but you have a duty to find that. That's what's called record notice. And record notice is a type of constructive notice, right? So constructive notice is like the umbrella category. And record notice is just one type of constructive notice. If there's some properly recorded interest, right, suggesting that prior owner conveyed Blackacre, right? But there's also something called inquiry notice. Ben, help us out here. What is inquiry notice? Inquiry.
Is it when like someone's asking about a particular thing that you should know?
That's a good guess. That's meaning to inquire. But we don't always have it that good where someone's talking to you, right? Think of the last case we did, right, with the Mother Hubbard clause, right, Luthi. And let's say you're buying some property and you see a Mother Hubbard clause somewhere in your chain of title, what does that make you do? What might that sort of trigger in your head?
Like maybe I should do some research or.
Yeah. You see something weird, and that realizes that something's up. I got to do more homework, right? Or let me use another example. Remember, we had an example last week where A purchased Blackacre in 1935, and didn't record till 1939. Right, there was like a 4 or 5 year gap between recording. If you're doing a title search and you find that there's a gap in the records where something was signed in 1935 and then recorded 5 years later, you don't know what happened in those 5 years. The law would impose upon you a duty to investigate what happened in those 5 years. And maybe you find some other deed that says Blackacre was conveyed, or maybe a mortgage was placed on Blackacre. You don't know, right? So inquiry notice is where you have some facts that come to your attention that cause a reasonable person to dig deeper, right? There are some facts that come to your attention that would cause a reasonable person to dig deeper. And if you fail to dig deeper, if you fail to investigate further, it's on you, right? That's your fault. You fail to actually investigate, and the law will not protect you, right? Now, why do I say the law will not protect you? We have this concept in contracts and property, the bona fide purchase for value, right? The BFP. You know this from other classes, right? The BFP. In order to be a BFP, you have to be acting in good faith, bona fide, right? That's what good faith means, bona, good faith, right? You cannot be acting in good faith if you knew your seller was a crook, right? If you knew that O doesn't really have Blackacre, you can't be a BFP. The only way you can claim to be a BFP is if you had no notice of any malfeasance, right? You have to have no notice. And that's where actual notice comes in. And that's where constructive notice comes in, right? If you did everything the law requires you to do and you still didn't discover the malfeasance, you're protected as a BFP. But if you did not do the investigation the law imposes upon you, you cannot claim later to be a bona fide purchase for value, right? You want to be able to be within that protection of being a BFP. All right, everyone with me so far? Yes, Ivan.
So with that, to what burden does the law impose that duty to?
Yeah.
Yes.
I'm sorry. I thought that was going somewhere else. What burdens?
Burden does the law impose for you to investigate?
Really, I'll give you an answer. You're not going to like it, but it's actual notice and constructive notice, right? Those are your burdens. If you have actual notice and you know something, you can't be a BFP. If there's constructive notice and you fail to find it, then you're not a BFP. The debate becomes is how much work do I have to do to actually investigate? So in the California, they said you're not required to investigate alternate spellings, right? That was the idem sonans case. Or in Kansas, they said when you see a Mother Hubbard clause, you're not required to investigate every possible property she owns. By contrast, in Texas, Mother Hubbard clauses are effective, and you do have that duty to investigate further. So it's a matter of state law of what burdens are imposed, but it's what's the sort of extent or the scope of what constructive notice requires. Alex?
Inquiry and inquiry notice are part of constructive
They're
notice,
types.
or-
Yeah. The terminology gets a little fuzzy, but the way I look at it is that constructive notice is like an umbrella. And under the umbrella, you have record notice and inquiry notice. That's how I see it. Maybe people disagree, but that's how I usually explain it. But actual means literally someone hands you the deed, to use Kayla's example, where someone tells you, I sold Blackacre to so and so. If you know that and you do it anyway, then you're off the. You can't claim to be a bona fide purchaser. All right, let's get another terminology. I think you're next, right? What does chain of title mean? This phrase, I've used it a dozen times already today. What does chain of title mean? Very good. All right, so the chain of title refers to a chain of transactions, right? But it has another meaning which is relevant here. This actually goes to Ivan's question as well. The chain of title refers to the documents that must be searched to be a bona fide purchaser, right? If you want to be a BFP, here are the documents you're required to search, that you're required to investigate. And the failure to investigate a document that's within the chain of title means you're not a BFP. Again, the failure to investigate a document that's within the chain of title means you're not a BFP. If there's some document outside the chain of title, you're not obligated to find it. So to use the Kansas example, right, with the Mother Hubbard clause, the law would not impose upon you the obligation to find every oil lease she had in the county. 1 second, right? That's outside the chain of title. Or in California, you don't have to find all the spellings of Elliot. That would be outside the chain of title. Hillary?
So is it the documents themselves or the period
Both.
of time?
Both. All the above. It's both. It's the documents in a given period of time. So maybe the law says, you have to investigate for 100 years. Go back. Maybe the law says you have to go back to the Louisiana Purchase, like he had the thing in Louisiana, right? It varies. But generally, the word chain of title refers to, as Wafa said, the sequence of transactions, but also refers to the sorts of documents that you have to investigate and find. All right. Oh, I'm sorry, Alexa, go ahead. Not necessarily, right? If you couldn't hear the question, does a chain of title only refer to things that are recorded? And not necessarily. There might be, think of the case yesterday, Harper, right? There might be a deed that's not been recorded that you still obligated to investigate, right? The chain of title can refer to documents that have not been recorded. And I think Harper vs. Paradise case today is a good illustration, right? A document sitting in a box somewhere for all those years, right, can still be in your chain of title because it was referenced in a recorded instrument, right? It was referenced somewhere else, and that's what you want to notice that, okay, there's another document. We don't know where it is. We can't find it, but it exists. Okay. Everyone with me? All right, let's jump ahead a little bit. Page 709, please. Example number 5. I'll put it on the screen if you don't have your book handy. You all should. Just curious, how many of you use the paper book? How many use electronic? How many electronic? Only electronic. How many paper? About half. Okay, that's interesting. Yeah, I publish the same company, the same red case book I have, and I always wonder how many people are doing the paper one versus it's so expensive to do the hardcover, and they don't charge enough of a discount for the paperback. The difference isn't there. All right, so look at example 5. Speak for Hillary in a moment. All right. It says O conveys to A, who does not record. All right. So in your own notes, you should be like numbering these transactions. So this is sentence just number 1, just like a little 1. Just trust me on this one because they're going to be. You talk about sequence of events. There's going to be a lot of them. Okay. So the first transaction is O conveys to A, who does not record. All right. Then it says in the next sentence, A conveys Blackacre to B. Okay. B records the A to B deed. So we have a problem, right? The O to A deed was not recorded. That was transaction number 1. Transaction number 2, the A to B deed was recorded. Third sentence, right? We see O conveys to C, who is a purchaser for value. Important to be a BFP, you have to have value, right? Who has no actual knowledge of the deed from O to A and from A to B. And then C records the O to C deed. So we have a conflict now. Who prevails? B or C? So Hillary, don't worry about the raised notice. That stuff doesn't really matter for now, okay? Let's just walk through this one step at a time, right? You're C. You go to O and you want to buy Blackacre. And you say, I am a diligent law student. I'm going to do my homework. Is there any way for you to know, Hillary, that O had previously sold Blackacre to A? Why not?
Because if I go to the index, I would see like a transaction.
You would not. But what about the A to B deed? Couldn't you find that? Perfect. Exactly right. There's no way for you to search for A. There's no way to search for B. You don't know who A is. You don't know who B is. All you know about is O. You only know the person selling it to you. Nothing would have put C on notice about A or B because this initial deed from A to B was, I'm sorry, from O to A was not reported. So Hillary, who prevails here? C prevails. C is a bona fide purchaser for value without notice. We'll get to the race notice stuff in a minute. That's not important right now, right? What's important here is C is a BFP. Okay, Jade.
Not be able to just like search the address or
Well,
something and find.
we
out
don't
what
have.
they
So you're saying going beyond the grantor grantee index, searching Google? I mean, what property
Or-
records?
Yeah, like property records or something.
The law does not impose on you an obligation to search other stuff. The law does not require you to Google. It says we have these books, grantor index, grantee index, and that's your obligation to search. Right?
So
There's
the notice is only within.
correct. Right now. If a person in fact did search the property records and saw, wait a minute, why is B paying property taxes on Blackacre? And they had actual notice, then they're not a BFP. Right? But there's no duty, there's no obligation to actually do that investigation. Or let's say, you're walking down the street and then you see B sitting in a lawn chair in front of Blackacre. Say, hey, what are you doing here? Oh, I own Blackacre. Right? That would make you go search the property records for B. And if you search for B, what are you going to find? You'll find the deed from A to B. You won't know how it went from O to A, but you know from A to B, that's enough to put you on notice to run away and not buy Blackacre. Yeah, Ben.
So is B not also a bona fide person?
B would be, but he's out of the picture. He sold Blackacre, so he's not involved in this transaction. B's gone. Once B sells his share in Blackacre, he's off the property. Right? I'm sorry. I'm sorry. I misheard you. You told me A or B. You asked about B. B is a bona fide purchaser as well, but I'm sorry, I didn't explain this part. The rule is that the subsequent bona fide purchaser prevails. I'm sorry. Hillary said I didn't. It's the subsequent BFP that prevails. It's one of these weird wrinkles of the law where you look to the later in time purchaser, the subsequent, or some people say subsequent purchaser of value. Okay, C prevails here because C is a subsequent bona fide purchaser for value. Alex?
And that's because, like, you wouldn't expect the person
Correct.
that is already occupied.
Yeah, the law protects the most recent buyer. So the weird thing of the law, but that's how they protect it. Alexa? The prior bona fide purchaser value, the earlier one, there's not really a name for it. But he's not subsequent, he's prior, earlier, I guess. B would be the prior purchaser value. I suppose you call him that. Yes. Oh, now you're asking an exam question, aren't you? So it gets very messy, right? No, I'm serious. You're anticipating where I can go with this, right? This is very clean, where there's two transactions at a time. But let's say that B sold to D and C sold to F, and so on and so on. It gets very messy. What I would encourage you to do is find who's the most recent BFP. There are dates on transactions, and usually when I ask an exam question, I put dates on the transactions on January 1st, on May 15th, whatever the date happens to be. And I think I would ask you to look for the most recent or the latest in time transaction. That'd be the subsequent. Not always. They get messy though. I'm just promising you. Hillary. He goes after. It's okay. It's actually curious, right? What does B do? Who is B in privity with, Hillary?
A.
Okay. So you can. What can he do to A? Anything? Right. So let's say that there was a general warranty deed, right? He could sue A, but I don't think A actually engaged in any misconduct. A was proper, right? What would have to happen is that O would have to be sued for fraud or unjust enrichment. The difficulty is, how does B get to O? There would need to be some sort of privity. So if B purchased a general warranty deed, I I think he could probably eventually get back up to O. But if B acquired Blackacre through a quit claim deed, I think he's out of luck. Right. So again, Hillary's question is, what is B's remedy? Eventually, you want to sue O for fraud or unjust enrichment, something, right? But to get there, you need privity, which might not exist. And again, going back to this question, imagine not just like having two purchases. Let's say there's 5 different layers of purchases. Can you go all the way back up to the top? Like imagine, I can do this on an exam. O sells Blackacre to 5 different people. Good luck. And they each sell to another person. It gets very complicated. All right. Everyone get that with the subcomponent fee to purchaser? We'll do the various recording statutes, which makes it a little bit trickier, but this is the basic idea. All right. All right. Go now back to page 697, please. 697. We're jumping back. And we shall do the first one, which is the race statute. Race, R-A-C-E. Not R-E-S, race, right? Alejandra, what is, just in plain English, a race statute? Finish sentence.
Without having knowledge of
No. Race statute. Let me ask the question differently.
the person who wins the race.
Wins the race what?
Record
And what do they get?
the plan.
Blackacre. Okay, good. That's what I was looking for. Just to finish the last part, right? A recording statute is a way to establish fair rules about who wins, right? You have a conflict between 2 different buyers. And it always happens the same way. O is a crook. O gives Blackacre to A, and O gives Blackacre to B. It always starts the same way. There's O is a fraudster. But then A and B have a conflict, right? Who wins? Does A win or does B win? The race statute is one way of resolving that conflict. And what the race statute says is, as between successive purchasers, right? As between A and B, person who wins the race to record prevails. The person who records first will prevail. One of them has to record. If neither records, neither of them will win. Right? But one of them records first, they prevail. Now I stopped Alejandra short. She started talking about notice and knowledge. That has no bearing on the race statute. The race statute is a bright line rule which law students tend to like. It's clear. You like that one, right? Yeah. It's clear, right? It's easy. You have a date on the deed. You look at the date. May 1st is before May 2nd. Boom, guy wins, right? Even if time of day, one person records it at 9 a.m., the other one records at 9:15. Okay, 9 a.m. wins. But the problems of this bright line is it can be very unfair because it might end up rewarding a person who's acting in bad faith, right? Because let's say O conveys to A, and then B knows about this, but he knows that A is out of town. He didn't get a chance to record yet. So B swoops in, buys Blackacre, records it before A comes home. Blackacre belongs to B, even though he's acting in bad faith. So with the race statute, it can reward bad faith actors, right? With the race statute, bona fide doesn't really matter. You can have knowledge of a prior purchase, and you still win. Unsurprisingly, the race statute is not very popular. I think your book says it exists in 2 states. Was it North Carolina and Louisiana? So maybe if you go to Louisiana, you'll see it. But most states do not use the race statute because it's a bit unfair. Right? So look at example 2. It says, O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O subsequently conveys Blackacre to B for valuable consideration. B actually knows the deed. So there's knowledge. He's not a BFP. But B records the deed from O to B first. Under the race statute, B prevails over A, even though B had knowledge, even though B is acting in bad faith. So this is not a popular regime, and only a handful of states have it. All right, questions on the race statute. This one's, yeah, that's easy. You like it, but it's not very nice, right? Next up, number 3. Ashrita, help us out here. What is the notice statute?
The notice statute is various between two conflicting statements, but inasmuch as a question of whether the subsequent purchaser has notice depends on facts not on record. Notice statutes are less efficient than race.
Okay, very good. Thank you so much. Texas has a notice statute. In fact, many states do. So this is what you're most likely going to be exposed to. So let's just look at example 3. I'll read it to you. It's on page, was it 698? It says, O, owner of Blackacre, conveys Blackacre to A, who does not record. Aha. O subsequently conveys Blackacre to B for consideration. B has no knowledge of A's deed. Under notice statute, B prevails over A, even though B does not record the deed from O to B. Okay. The notice statute focuses on, did the subsequent purchaser have notice? If he had notice, he is not a BFP. He loses. If he did not have notice, he's a BFP and he prevails. Even though he's a subsequent buyer, this was example 5 we did a minute ago. If he's a subsequent buyer without notice, he prevails. If he's a subsequent buyer with notice, he loses. It doesn't matter if he recorded, right? So it flips the race statute away, right? We don't care about recording. It's based entirely on, did the subsequent buyer have notice? Now, sorry, Hilary, please.
You know how in AP we have like disabilities?
You talking adverse possession? Okay, make sure. You mean, so let's say a person with disability buys Blackacre and can't record for whatever reason? Nah. Under a race statute, there's no tolling or anything like that. Now, Fernando, let me ask you a question, sir. What is the sort of the you would say the benefits of a notice statute? Why might a jurisdiction like Texas adopt this statute?
I guess it'd be more of a fairness.
Yeah. Why is it more fair? I think that's right.
I guess if you have competing claims to the same property, it would be a way to establish, did you have an opportunity? Did you have notice? Did you do your due diligence? Are you acting in good faith?
Good. Are you rewarding the bad faith person like in Louisiana here?
Right.
Yeah. Under the Texas statute, we're not rewarding bad faith. Under the Texas statute, we are not rewarding bad faith. In Louisiana, they do. Okay. So Duke, let me ask you the flip side of the question. What's the downside to the Texas regime notice? Why might this be a problematic regime to adopt?
Because the original purchaser gets the I'm saying politically correct. He doesn't get anything.
Well, okay, so person A gets nothing, right? But that might be the same rule in the race statute, right? Specifically here, what's problematic about a notice statute? Why might this be difficult for the courts to implement?
Because of knowledge.
Ah, you got it. See, I knew it into the question. Yeah. What do you mean knowledge? Elaborate.
In other words, it would be difficult to prove
Good.
if the
Good.
subsequent purchaser had knowledge.
It's an evidentiary issue, right? I think Ashrita made this point a moment ago. You have to look the facts, not the record, to try to impute knowledge, right? Whenever you have a litigation over state of mind, think of adverse possession, or think of like, murder versus manslaughter. Proving state of mind is not easy because it requires looking to extrinsic facts, right? What did a person know? When did they learn it? How diligent was their search? What records did they look at? Did someone mention to them? Do they, awareness of property tax records, right? There are all these other facts in a notice jurisdiction that have to come into play. And the final fact, the court or the jury has to decide, did this person have knowledge? So the race statute is very easy to apply, bright line rule, right? The notice statute is very subjective, and it goes into a lot of subjective state of mind, what a person was thinking. Then
So then A would just have to prove that he had conflicted notice.
correct, which is very hard to do, right? Especially in the example he gave you here. There's no deed to put a B on notice. An example we did a few moments ago, the Hillary answer, there was this broken deed somewhere, wherever there was like this chain of title break. You couldn't find it. So you have to make these very delicate questions of whether the person had notice. Duke?
So there's no limit. I hope it's been on this.
100 people. Yeah, imagine, if there was a movie, The Producers, right? Where these Broadway producers were selling shares of a play that add up to more than 100%, right? So they basically sold to like hundreds of people the exact same share of property. Imagine you're a fraudster, right? And you're selling the same oil and gas reserve to 100 different people, and you just run for the hills and get out of town, give everyone a quick claim deed. Yeah. Who the heck is a BFP in that case? Oh, Alexis, please. Isn't the guy who's going to lose? Yeah. So the burden is on the guy who's about to lose. It's not the subsequent. It's on the earlier one, right? But really think that they both have burdens. Think about it just like this, right? Because let's just say in this case, A is going to try to show that B had constructive knowledge. And the B is going to show, no, I didn't have knowledge. So really, they're both burdening each other, right? So I think you'd say that A has the burden to show there was constructive knowledge, and then B can then rebut that burden. I think it's how I would phrase it. But yeah, they're both fine. It's like, you knew, I didn't know. It's like one of these squabbles. Was that a hand? Yeah.
What would happen if they killed 100 people?
Oh, that's fraud. I mean, think of like Bernie Madoff or like these Ponzi scams where people or Bitcoin, right? Where FTX, right? Where people sell the same thing to many people and they charge over and over again. You can't do it. That's fraud. Security fraud, wire fraud. There's crimes at play here. I don't care about the criminal stuff. That's beyond my class. I care about what B. All I care about is between A and B. What happens to O? That's his business. Yeah. Answer your question.
Yes.
All right, everyone with me on this example, number 3. So again, the race statute is a lot easier to apply. It's clean. The notice statute is a bit more fair, but it's a lot harder to apply. If you just look at, I should have it up here, the Texas code. Not that you'll ever need to look at this, perhaps, but we have in this jurisdiction, where is it? Okay, a notice jurisdiction, right? It's blah 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 blah. Person and location made had actual notice for the older title, right? And there's another provision about constructive notice. Don't worry about it for here. But Texas has a notice statute. Okay. Everyone with me on notice. All right, who's up next? Oh, you're blocking your name tag. I'm so sorry. Johnny. Yeah, Johnny. Thank you. I remember it. I wasn't sure. Johnny, the hardest one is the third one. This one that gives students the most difficulty every year. What is a race notice statute? A race notice statute.
The combination of the race.
And that's for an end. Put a big A and D in your notes. Go on, Johnny. End. Good. I'll give you the definition again in a moment, but let me do the example, number 4. I think this one's actually easier to do with an example than the definition. Johnny gave a perfect definition. Let me give you an example. All right, so here we have O, owner of Blackacre. I'm sorry, this is example 4. O, owner of Blackacre, conveys Blackacre to A, who does not record. Okay, that's deed number 1, period. O subsequently conveys Blackacre to B, who does not know of A's deed. Okay, so B is a bona fide purchaser of value, does not have notice. But then we have a conflict. A records, and B records. A records and B records. So I'll say, let me just pause you here for a minute, right? Let's say the exact same facts and we're in a race jurisdiction. A records and B records. Who wins here? We're in Louisiana here.
In a race.
Yes, we're in Louisiana. A records and B records. Who prevails here?
A.
That's correct. Why?
Because even though B was a subsequent bona fide purchaser, without notice, he failed to report first.
Correct. Correct. Good. Alex, let's say now we're in Texas, right? Same facts. A records and B records. Who prevails here? We're in notice jurisdiction. Why? Correct. B is a subsequent bona fide purchase for value, takes that notice. B prevails in Texas. I was trying to go. Did I do it last time, or am I going that way? Sinclair. All right, so Sinclair. Now let's go to our question. I don't. What? No. I try to be fair. I don't always do the roads the same way, and I just kind of forget. But let's do now the question we have here, Sinclair. We're now in California. We have the race notice jurisdiction, right? B took without notice. A recorded first, then B recorded. Who wins here?
Well, isn't it unclear because it's like split? Because you have to have
One of them has to win.
it's B because didn't have notice and he recorded.
Who recorded first?
Oh, A.
Try it again.
Okay, so wait, it's A.
Well, tell me why.
Well, because A recorded first. And
Does it matter that B had no notice? Does that matter here? What do you have to have? You have to have two things to prevail. What are the two things you have to prevail?
You have to have recorded for the prior instrument
And
without notice.
correct. Very good. Thank you, Sinclair. In order to win in California, two things have to be true. Both of them have to be true. Number one, the subsequent purchaser had no notice. And number two, the subsequent purchaser recorded first. Again, to prevail in a race notice jurisdiction, two things must be true. You gotta have both of them. Number one, the subsequent purchaser lacked notice. Number two, the subsequent purchaser recorded first. In this question, only one of those things is true, right? B does not have notice. B lacks notice. Good. But he doesn't check off the second box because he didn't record first. He recorded second. And therefore, under a race notice statute, A prevails. So again, think about this exact question three ways. In Louisiana, A wins. In Texas, B wins. In California, A wins. The exact same fact pattern can give you a different answer depending what jurisdiction you're in. So you must be very careful when you're answering these questions to make sure you're applying the correct recording statute. Yes, on the exam, I'll tell you what statute you're in, right? I'll tell you. I might make you know that Texas has a notice statute. I think that's fair game, but you'll at least need to know that much. Okay. Usually in the exams, it's terrible. I pick either Texas, California, New Jersey. Those are usually the states I pick because it's usually very clear which jurisdiction those rules come with. Ben?
So in the eyes of the court,
The eyes of the court. Yeah, I like that.
in,
The eyes of Texas are watching.
is Inquire notice the same thing as constructive notice?
This was Alex's question before. Constructive notice is like the umbrella, right? And under constructive notice, you have inquiry notice and record notice. Those are different types of constructive notice, right? I did. I said it again. It's good. I think I said it the same way even. All right, everyone's been race notice. So the race notice statute tries to like merge the best and the worst, I suppose, of the other two, right? So it rewards both timely recording and it rewards BFPs, but you got to have both. It's not enough to be a BFP. You need to record first. Really punishes those who don't record first. I mean, that's it. Sort of brings in the race aspect. Hillary. Yeah, right. The shelter rule, I was going to get to a little bit later, but I'll just mention it now. If a person's a BFP, right? In this case, we said that B is our BFP, and you buy it from your BFP, you step into their shoes. Again, it's called the shelter rule. SHELTER, shelter rule. Think of like an animal shelter thing, protection. If you purchase from a BFP, you step into their shoes and you get their protections. So if you're a person, a subsequent buyer, you might want to show that the guy who came before you was in fact a BFP, and show that he had no constructive notice, no actual notice. But yes, that comes up. Would you? Is it cool? Good. But all right, everyone with me on the race notice stuff. All right. 45 minutes. All right. Let's do some questions. So we have polling questions. We'll do Harper towards the end. We're good on time, so we have time for these. Let's do question number 1. Multiple choice. Go. O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O subsequently conveys Blackacre to B for valuable consideration. B actually knows the deed to A, then B records the deed from O to B. Who prevails under a race statute? All right, and this will be for, I think, Anna. I think you're next. Okay, give another 5 seconds, then we'll call on you. Okay, what is your answer? Why do you say B? Doesn't matter. He had notice. Correct. Good. Good. 95%. I am impressed. That's very good. Okay. All right. I think maybe we got this one, right? At least we have this much, right? With the race statute, all you care about is who records first. And if you're in the 5%, I'm sorry. But 95%, I'll take that any day. Okay, let's look at question number 2. Okay. This will be for Joe in a few moments. Okay. O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O subsequently conveys Blackacre to B for valuable consideration. B actually knows of the deed to B. The deed to A. B records the deed from O to B. It knows exact same fact patterns before. I just copy and pasted. Who prevails under the notice statute? Okay, take another 15 seconds. Okay. All right, Joe. What is your answer here? Why is your answer A? Is B a bona fide purchaser for value here? No, that's correct. So 98%. Look at this. So I'm very happy. This is not an easy topic. You guys are doing well. I'm very, very proud. Okay. A prevails. B took with notice. He's not a BFP. He cannot take advantage of the recording statute. All right. Let's try. Speak for Clayton in a few moments. Question 3. I'm going to read it again. The exact same facts, but with a race notice jurisdiction. Okay, another 15 seconds. Yes.
Did you say that Texas is a notice?
Notice. No, Texas is notice. That's in the book also.
Okay.
Yep. All right, Clayton. What is your answer, sir? Why do you say B? We're in a race notice jurisdiction. Oh. Okay, you changing your answer? Why are you saying A? Okay, we're in a race notice jurisdiction, right? Okay, so what are the Clayton, let's help us out here. What are the two things you must show to prevail in a race notice jurisdiction? I'll give you two things. What are they? Okay. Okay. So did the subsequent did the subsequent purchaser record first?
Yes.
Okay, so you check that box, right?
Right.
Did the subsequent purchaser have notice?
Yes.
Ah, so you check the first box?
No. So
Correct. A wins. Even though B recorded first, A took with notice. Okay? Therefore, the subsequent purchaser does not win. You notice, again, questions 1 and 3 come out the same way. Right? You did that in 85%. Okay, 85%. I can live with that, right? Some people got tripped up. Questions 1 and 3 come out the same way. Usually with a race statute and a race notice statute, you get burned on the recording. That's usually we get burned. They come out the same way. But question 2 on the notice statute comes out differently. All right, good. I'm happy. 85%. I can live with that. Good. Questions on this number 3. All right, Kendall, let's review number 4. Let's take some time on this one. Okay. Okay. O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O conveys to B for consideration. B has no knowledge. Who prevails under a under a notice statute? Excuse me. All right, another 10 seconds. Okay, what's your answer, Kendall? Okay, why is B prevail? Yeah, B had no notice. Exactly right. No notice. All right, good. Let's see what we got. Oh man, 95%. I mean, happy. Good. All right, let's try question 5. This is for DR. Almost. I think I only have a couple more of these. We'll be done with these soon. But we're blowing through these, which is taking much less time than expected. So I'm happy. I mean, that's always a trick, right? You take more time in these questions, you have less time for the cases, but that's how it goes. Okay, so 5. O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O then conveys it to B for consideration. B has no knowledge of the deed. Oop. Oh, don't ask that question. I'm trying to.
Sorry.
Yeah, I was actually like dreading someone asking that question because it ruins my question. I know you did. That's why I want you to answer the thing with the poll. You guys are too much. No, you're smart. It's good. Like you're thinking the right way, but you're trying to kill my question. Okay. All right, another 10 seconds. All right. Let me stop at the DR. So Hillary asked a question. I'm sure you assume it was in your mind. How did you answer the question, A or B? Okay, why'd you say that? But did I ever say whether B recorded or not? Did I say anything about B recording? So do you assume he recorded or assume he doesn't? Right. Okay. So to Hillary's question and to call a few others, unless I tell you there's recording, assume there's no recording, right? Unless I tell you that B recorded, you assume there's not. If the question is silent, you assume it never happened. That's why I put this question in the poll, but not a couple of you jumped to the gun, right? But yeah, that's correct. A prevails because under a race notice statute, subsequent buyer must record, And they record, oh, look at that. Someone put C. I can't help that person, right? That's not an option. There's no option. See, look at the thing. There's no option. I appreciate your honesty. You know what? He could have just kept quiet and put his head down, but he put his hand up. So I appreciate it. But look, this one's actually pretty split. Now, for those of you who said that B prevails, did you assume B recorded? I saw you guys were talking also. I was like, yeah. No, I know. Unless, and this is why I put this question here on the board, right? Unless I tell you there's a recording, assume there's not. Don't. This is a good rule of thumb for law school. Don't assume facts on evidence. That's how. Oh, it kills me when a law student does something like, oh man, when they assume a fact that I didn't put in there, and I deliberately omitted, and then they just run with it. It's that one breaks my heart. Yes, Jade.
If A also didn't record,
If neither recorded,
but B still meets password.
doesn't matter. Neither wins. Yeah, that's actually a good question. You should mention. I forgot to mention it. Let's say that A never records and B never records, and you're in California. If no one recorded, neither one of them can take advantage of the statute. But what's going to happen in real life, Jade? As soon as they realize something's up, they're going to race to the courthouse. They're going to get their sneakers on. They're going as fast as they can, and they're going to get there to record because whoever records first wins. Right? So, as a practical matter, yes, maybe neither records and there's no winner. But as soon as they realize there's a conflict, off to the court. That's why it's called a race statute. It's a race to the courthouse. It's literally what the statute means.
So in this one that we just did, like that's a situation where nobody wins.
Well, no. I told you that A records.
Oh, you did? Okay, never mind.
Yeah, that was in the question. A records. That's in there, right? I think I said A records. No, I think I did. Did I do that? Oh man. Well, you know what? A would win. No. Okay, let me think about this like this. No, I'm right. The reason why A wins is because B cannot win. Right? Think of it this way, right? B cannot win because he doesn't satisfy the two criteria. The race no statute is only about the bona fide purchaser, right? B can't win because he never recorded first, right? Because B can't win, by definition, someone has to win the case. So I think the court would give it to A, right? But I still think that if this sort of thing happens and neither of them record, when they find out about this conflict, they run to the court to report first. Does that make sense? In other words, someone has to win, right? The court has to give, there's a case between A and B, the court has to pick a winner. So I think in this case, the reason why I posed a question like this is the court would pick A because B can't satisfy the recording statute. Does that make sense? You don't like it. Okay.
Because A can't satisfy it either.
But that's the point. A doesn't have to satisfy it, right? The recording statute is only about the subsequent bona fide purchaser. I think that's the way it would have to work. Yeah.
That was kind of my question. Is that because he can never be a subsequent bona fide purchaser because he put on notice that A had brought it first, and so
Right. If A had recorded, then B cannot be bona fide. That's right. Right. Yeah.
So you said like if they were to find out something's up and they would raise the report.
Right.
When does notice? When does B get notice? Do you have notice before the purchase?
Yeah, no, yeah, you're going down where I didn't want to do this, but I'm happy to answer your question, right? So think of it this way, right? Neither of them record. A doesn't record, B doesn't record. And then you have this conflict, right? At this point, they already purchased it. If you record after you purchase it, you can still be the first to record. So if A records first after the purchase, he still wins, even if he didn't record before the lawsuit began.
Right, but if B was put on notice after he purchased it and then went to
He still BFP. He can still be BFP. Right. Correct. Yes. Right. You have to be a bona fide purchaser when you're buying it. If you learn after the fact, that's what leads to litigation. And you might imagine that B learns about this prior deed later, and he records first, and that's how he wins. But the trick is, imagine that A learns about this. Hey, why is B on Blackacre? And then he figures out what happens. Then A goes to record right away. Then he wins. He beats off B. Fernando.
I'm sorry, in the state of this question,
So I hate multiple choice. Yeah, go on.
no, just out of curiosity, what role does possession play in a real life scenario? If we have a situation.
What do you mean
somebody
possession?
recorded- Well, one of these potential buyers would maybe at some point take possession.
Right. So after you buy it, let's say that B moves in, and then A sees that, and that might trigger A to say, "Wait a minute, let me go record immediately." Or maybe when B gets there, he sees that A's living on Blackacre. B goes to record right away, which is why again it's sort of a fun law school question. What happens if neither of them record? But as a realistic matter, if this ever gets to conflict, they're going to record as fast as they humanly can, and then they'll win under the recording statute. But to Esther Ita's question, you can record after all the transactions are done. You can still win. Good questions. I like that. Okay, I'll do that one cleaner this afternoon. No, it's good. It's almost unfair because like I try it out. If it doesn't work, I do a little bit different later. Anyway, you get the better stuff. I'm less tired. I think that's probably the upshot. All right, let's do question 6. Yeah, one more after that. Let's look at question 6. This will be for Marcel. I think is next. He's been patiently waiting all this time. I'm sorry. I know the I once had a kid on deck for 45 minutes. I went on a discussion. Something he was just dying. I could tell he was just waiting. All right. So question. What?
Yeah, noted.
I think it was in con law where we went on some tangents, but he eventually got back to him. Okay, number 6. Owner Blackacre conveys to A who does not record. O subsequently conveys Blackacre to B who does not know of A's deed. Then A records and B records. So again, these are recording after the transactions close. This was her question from a minute ago, right? You record after the transactions are closed. Who prevails in number 6 under a notice statute? Okay. Another 10 seconds. All right, Marcel. What is your thinking here? Okay, why do you say B? Does it matter that A recorded first? Under a notice jurisdiction does not. This answer is B. All right, 75%. I can live with that. Anyone put A want to make some what? Yeah, Caitlin, Alexis, go.
Once A recorded, then B would have the duty to know, like to go check.
No. Your duty of a BFP ends after you buy Blackacre. You have no ongoing duty to search. No. Don't be Najos. Right, it's a fair point, right? That's why I asked. I thought someone was going to say that. After the transaction closes, right? You bought Blackacre. You no longer have a duty of investigation. The duty of due diligence ends after you buy Blackacre. Right? You don't have to see what I mean. Imagine if maybe you buy a house. After you buy the house, you have no duty to go to the records office every week to see what's been recorded there, right? So here, you look what happened when the deal closed, and then your duty is complete. At the time of the transaction, Caitlin, was he a BFP?
A or B.
I'm sorry, was B a BFP?
Yeah.
Correct. At closing, was B a BFP? Correct. Then he's a BFP for life, and his successors would BFP as well under the shelter rule. Okay, that's why I thought that's what the quarter of you put, but that's good. 75% still pretty good.
So usually like a transaction can last like a month. When the title company is doing their title search, do they keep on title searching up until closing, or do they check once?
Yeah, no, it's a really hard question. At least in my experience, and everyone else can raise their hand, the title company does their search. They just call an abstract of title. It's like a document. And I don't think they go back into it if there's some documents filed the next week. What I would say is that if you are a buyer and a title company gives you an abstract of title, and then like the next day something's filed, I think you can still be considered BFP. I mean, you have to have some reasonable standard. they're not living at the records office finding any new deeds are recorded. But it does get tricky because if the closing takes a few months, there might be new developments, and maybe tell your title company go take another look, see if anything new is filed in the last few weeks. All right, we're going with question 6. All right, one more, then we'll move on. I think we're doing pretty good. I'm actually pleased with these numbers. Number 7. It's before Jose in a few moments. All right, number 7. Facts are the same as 6, but now we're in a race notice jurisdiction. Same facts as 6, but race notice. All right, another 10 seconds or so. Okie dokie. All right, Jose, what's your answer? Why do you say A? Okay, so there are 2 requirements to win in a race notice jurisdiction. Just humor me because it becomes important. What are the 2 requirements for a subsequent purchaser to win in a race notice jurisdiction? Good. Okay, stop right there. Did BS have notice of a prior instrument?
No, he did not have that.
Okay, okay, check. What's the next requirement?
The report into the fire.
Good. Did B record first? Correct. So who wins? Good. A is the answer. Right? A is the answer. And again, when you're doing a race notice statute, just list those 2 requirements and check them off because I can mess with the facts and I can make it a little bit trickier. Like I can do it that B records first, but he had notice, right? 193%, really good. Only a couple of you got this one wrong. Very good. All right, I'm gonna just assume you understand this topic because these numbers are pretty strong. You're shaking your head. No?
I thought I got it.
You good? Good? Okay. Questions on this topic? Questions on this topic? No? All right, Nate, facts please. Harper versus Paradise.
In Georgia Supreme Court, 1974, claiming student Harper 1922 granted from daughter-in-law Harper a life estate. That deed conveying interest in the place wasn't signed again until 1957. Then it was recorded in 1957.
Okay.
Susan, who dies sometime in 25, 27.
We don't know. It's no weird. We don't know when she died. Just ballpark, right? Because they have no idea. Yeah, you've been there. Yeah.
So in 1928, Susan's legal heirs execute document.
All of them or some of them?
Legal heirs, it says.
All right. Okay.
Execute document acknowledges that the deed from Susan's mod had been misplaced and conveyed mod their interest in the spot. Then according to 28. Oh, and then mod used the property to secure a loan.
Yeah. Okay.
And then
what happened? What happened after that?
Defaulted.
Yeah, that's not good.
Property received, shares deed executed and recorded in 36.
Okay, very good. All right, thank you for that, Nate. Okay, so this is a classic family dispute, right? Susan was Maud's mother-in-law. Did Susan love Maud? Not that much. Why? Because Susan gave Maud a life estate. And if you love someone, you say it with a fee simple. Hey, oh, you guys, for Valentine's Day, we're covered, right? Don't. It's in 2 weeks. Don't say it with diamond. Say it with fee simple, right? 2 months salary to buy, a Blackacre. That's the rock they want, right? Don't listen to me. But it seems that Susan didn't really trust Maud, and maybe in hindsight that was a good call. because Maud mortgaged a thing for like $50 and then defaulted on it, right? So maybe Maud wasn't the most responsible person. We don't know. The remainder would go in fee simple to Maud's children. So I think Susan really liked the kids and not necessarily Maud. Again, they were not blood relatives; it was a mother-in-law. So basically, Susan gave her daughter-in-law a life estate and gave her grandkids the remainder in fee simple. We know what was up there, right? That's what was going on. But the deed went missing. Poof. But everything was fine, right? Maud continued living on Blackacre, and then Susan died a couple years later. Then a few years later, 3 of Susan's 4 heirs, not all of them, 3 of the 4, so we don't know who the 4th one is, executes a deed to the benefit of Maud. Again, the mother-in-law only gave a life estate. But the heirs said, okay, we have this deed from 1922. We don't know where it is. This deed was lost or destroyed and cannot be found. And the heirs gave whatever interest they had to Maud. Now, what's the problem here, Alexa? At that point, who had the future interest in Blackacre? Who had the future interest in Blackacre in 1928? Yes. Whose children? Maud's children that are remainder in fee simple, right? What could Susan's children have? What could Susan's heirs have possibly given Maud? What could they even give her? They can't give her fee simple. The future interest belongs to the kids. What's the most they could have given Maud? A life estate, right? So again, they say we give whatever we can give, but at most that was a life estate. It's not clear that this transaction did anything, right? She already had the life estate by virtue of the deed. Deeds can go missing, right? They're still effective. Imagine you have a deed in your safe and your house burns down. You don't lose Blackacre. So it's not clear what it was saying we're giving Maud our interest. I think there's basically no legal effect there, not much. But the deed in 28 says, oh, there's this other deed from 22 that was lost or destroyed. It cannot be found. And they say, by the way, this 1928 deed will take the place of the 1922 deed. Jordan, does that work? Can you do that? Can the heirs, or at least 3 of the 4 heirs of Susan, just replace a deed? Is that even possible?
I don't. So
Not really. I don't know what this is, right? The deed doesn't actually do anything, and it doesn't really take the place, right? Statute of frauds, you can't unwind a deed by writing a new document. Now, there's nothing wrong with the children of Maud, the children of Susan, giving Maud whatever interest they have in Blackacre, right? They can do that, but you can't simply take the place of an earlier deed. It doesn't work. There's nothing that can be done here. All right, so then we fast forward a few years. Maud apparently is not the best with her money, and she puts a $50 loan, which is not a lot, secured by her property, which means she didn't take it very seriously. Maybe Susan was right not to give her the life fee simple, right? Look, if you love it, say with a fee simple. She defaulted on the loan, and then we learned about foreclosure. We did foreclosure last week, right? And as a result of the foreclosure, there was an auction, a sheriff's sale, and then a Thornton purchases at the sheriff's sale. He records the deed from the sheriff in 36, and he moved in 4 years later. Right? 15 years later in 55, Paradise buys Blackacre. All right. Then magically, in 57, the OG, right, the original deed was discovered. Where was it? Poof, in a drawer somewhere, whatever, right? It's magic. I mean, you'd be amazed. I recently cleaned up my parents' house in New York, and the stuff you find in boxes and crates, it just sits around forever, right? Just stuff just sits. It just sits for decades. That was 57. And then July 57, the original deed was recorded from Susan to Maud. Okay, so now what happens? Caitlin, let me ask you a question. when the sheriff foreclosed on Blackacre, right? What interest was actually sold to Thornton when they foreclosed on Blackacre? When Miss Maud defaulted, what's the only interest that the sheriff could have foreclosed on? Sorry.
Interest in like the loan.
Did Miss Thornton? Did Maud have a fee simple on Blackacre? What was her interest? So what interest was foreclosed upon?
The life estate?
That's right. And so when Thornton acquired a deed to Blackacre, what was the actual interest he was acquiring?
The life estate.
Measured by whose life? Correct. All Thornton could have acquired was the life estate measured by Maud. If you remember the French, remember the French? What's that thing called? Anyone? Yeah.
Sure.
Oh, good. Life estate per Autrevie. PURAUTREVIE. Life estate per Autrevie, which is a life estate measured by a third party. So really, what Thornton acquired was a life estate per Autrevie measured by Maud's life, and that's what Paradise got. Right? In 72, Maud died. And once Maud's dead, who gets the remainder? Maud's children. So they show up. And they say, hey, Blackacre's mine. I want Blackacre. Right? Alexis, what did the Paradises argue about why the kids didn't get the remainder?
I believe they were saying they recorded first under the
Correct. Correct. What else, though, did the Paradises argue? What was the effect of the 1928 deed?
Well, they said that they had the same effect as the 1922.
Do they think the 1928 deed gave Maud a fee simple or life estate? What did Paradise argue? What was the effect of the 28 deed?
It says they were derived from the same source.
Okay.
So the living heirs must be treated as having.
Let me ask you differently, right? Alexis, you're the lawyer for the Paradises. What estate did you want Maud to have? Did you want to have a life estate?
I wanted her to have fee simple.
You wanted her to have fee simple. Why?
So she has complete ownership.
Correct. Good. So Jade, let me ask you this follow-up, please. What's the argument that Maud had a fee simple? What's the only argument that they can make?
That the 1928 deed was the correct
And it gave her what?
a fee simple.
Correct. The Paradises argue that the 1928 deed gave fee simple to Maud. Again, the Paradises argue that the 1928 deed gave fee simple to Maud. That argument doesn't work, right? The children of Susan could not eliminate the future interest, the remainder, right? That remainder was a vested right, a vested remainder, to use a lingo, right? It's a vested remainder. It cannot be wiped out by the heirs. That's what the Paradises argued. Okay? But that's actually not why this case is in your book. Oh, I got everyone, right? What did I didn't do that side? Will, you thought you were going to skate. Will, I'm sorry, Maxim's on deck eventually, right? Will, if you were doing a title search, right, and you find the 1928 deed, what might your reaction be? What might put you sort of, use a phrase, your spider senses are tingling, right? What might get you a little bit nervous?
Mind the kids.
I'm sorry?
Mind the kids.
You're Paradise. You're Thornton, right?
Oh,
You're doing a title search on Blackacre and you find this deed from 1928. What might make you nervous?
that's someone might come out of the woodworks.
Well, why? What might make you nervous? Very specific language in the deed that might make you nervous.
Notice.
There's notice, but give me more specific.
Constructive notice.
What about it's giving constructive notice?
The finding of it.
The 28 deed makes reference to something. What does it make reference to?
Oh, the.
I heard that. I don't think he heard it, but I heard it. What's reference in the 28 deed that's relevant here?
the remainder to her kid?
No, Justin.
The first.
The 22 deed.
Oh,
And why is that significant? Well, why is it significant? The 28 deed references the missing 22 deeds. Why should that put you? Why should that make you nervous if you're the buyer?
but then you do have notice.
Notice of what? What might be problematic?
The 1922,
And why might that be problematic if you know about that?
because that it gave the remainder to the kid.
Do you know what the 22 deed said?
It gave the.
No, but if you just see the 28 deed, do you know what the 22 deed said?
Oh no, you just made aware of it.
You have no idea. You don't know what interest was given to Maud in 1922. You have no idea. And that is a risk because it turns out all Maud was given was a life estate. And the 28 deed purport to give her a fee simple, but it can't. So they were put on constructive notice. I would call this inquiry notice, right? If you having a deed from 1928 says there's this other deed that's missing, how about you say, can I please see that deed? And if they can't produce it, you run. You get the heck out of town. You do not buy that property. Because all Maud had was a life estate. And as you know, when the life estate terminates, the future interest goes to the remainder, to the children. Right? So this is a case where the 1928 deed clearly put subsequent purchasers on notice of the earlier one. This is constructive notice, inquiry notice, if you will. Okay? Yes, Maxim.
So are constructive and inquiry notice interchangeable?
Alex, you want to answer the question the third time today? Go ahead. Yeah, go. Yeah, answer. Yeah, I already did. I'm done already. Yeah. Good. Not what? Go check the recording later. I said this one 3 times. Okay. All right. What else? Yeah, Clayton. Who's they? Just be sorry.
Okay, if the creditor knew about the deed and knew about her remainder being a life estate,
Right.
then when the children take the property, would they inherit her debt for $50?
Well, to be clear, this is an important point. If you own Blackacre and you go to a bank and you ask to put a loan on it, the only mortgage they're placing is on your life estate. And after the life estate ends, the debt vanishes. And that's why if you have a life estate, no bank will write you a mortgage because if you just die, that's it. The interest extinguishes and the remainderment come in with fee simple. Yeah, so there's no debt for the children. The last part of the case, which is not terribly important, which is adverse possession, right? Why does this not work, Cole? Why does the adverse possession argument not work?
They claim they adversely possessed from the time frame that they weren't actually on the land.
Well, assume you have tacking, right? Assume there's tacking. Why does adverse possession not work here?
Also because the remainder,
Good.
they were unable to protect their interest because they had invested
Whose interest were they squatting on?
the odds named children.
No. So all those years that Maud had a life estate, right?
Oh yeah, that'd be her interest. So they would like to.
Correct. And what happens when she dies? So all at most, they adversely possessed a life estate, right? Imagine you're like Mr. Robinson, right? You're just saying, oh, this is awesome. I'm going to spend 5 years living in this house, chilling out, right? And then you get adverse possession. Guess what? You adversely possessed the life estate. And upon the death of Maud, that interest vanishes. And you now have the remainderment come in. Again, with a life estate for Atra V, there's a clock. And as soon as Maud dies, whatever interest you have vanishes. So the adverse possession doesn't work. The paradises lose, and the children of Maud come in with fee simple. They win. All right, everyone understand that issue. I like this case. I think this case got exactly correct. It's rare that a case every single part of yep, that's right. So let me just summarize for a bit. The reference to the 22 deed in the 28 deed, put them on constructive notice. And inquiry notice is a type of constructive notice. Inquiry notice is a type of constructive notice. Got that? Yep. Okay. When we're dealing with adverse possession in this issue, the adverse possession only extends to the interest at hand. All right. All right. Questions on Harper? I like this case. All right. So we did a lot today. I'm actually very pleased with your numbers. Your numbers were good on the race notice and the notice statutes. If you didn't get these all right, just go back and redo the questions. Anything else in your minds? All right. I shall put the poll open. I'll be in the office if you need me. Happy to chat. Thank you. And my new microphone held up, so I'm good. So it's the audio.